I'm discussing on topic definition and nature of contract. Contract comes under Indian Contract Act 1872. The act came into force with effect from 1st September 1872 and the act is applicable to whole of India except the state of Jammu and Kashmir. This act is divided into two parts. One is general principles of law of contract and other is special type of contracts. General principles of law of contract are contained under section 1 to 75 and here it is applicable to all type of contracts irrespective of their nature. The other one, special type of contracts, are contained under section 124 to 238. These include contracts of indemnity and guarantee, bailment and pledge, agency, etc. Before we start, let us understand the term or word contract. The word contract affects every person who lives in this organized society. For example, when a person buys a computer, car, bicycle, or hires a taxi, or takes a credit card, or does bookings for train, planes, etc., he enters into contracts, though he may be unaware of all these facts. Now let us see the definition of contract. According to Salmond, contract is an agreement enforceable by law. According to this definition, contract is composed of two words, that is agreement plus enforceability by law. Now let us understand what is agreement. An agreement involves proposal or offer by one party and acceptance of the same by the other party. In this, one party offers and the other party gives his acceptance. For example, X offers to sell his car to Y for rupees 1 lakh and Y accepts the same. This is an agreement. So agreement is where there is offer plus acceptance. X offers and Y gives his acceptance, then it is said to be an agreement. The other essential for contract is enforceability by law. Enforceability means recognized by court of law. That is, if one party fails to perform his promise, then the other party can go to court of law to claim his right legally. Thus, an agreement to become a contract must give rise to a legal obligation. In the previous example, when X offers to sell his car for rupees 1 lakh to Y and Y accepts the same, later on, if X refuses or fails to perform his obligation, that is to sell his car, then Y can go to court of law and can sue X for not performing his obligations. So that agreement involves legal obligations or legal conditions and that is enforceable by law. So a contract is composed of two words, that is agreement plus enforceability by law. There must be agreement, that is offer and acceptance, and there must be enforceability by law, that is creation of legal relations. Let us take another example. X invited B for a birthday party. Now, B accepts the invitation. It is also a promise, it is also agreement, but it is not creating any legal obligations or relations. So this is mere social or domestic agreement. So if agreements is social or domestic, it is not creating any enforceability by law. Such agreements are only social or domestic agreements. But in order to form a contract, an agreement must have enforceability by law. There is another famous case of Balfour versus Balfour. In this case, Balfour lives in Ceylon, while Mrs. Balfour, owing to his ill health, stays in England. During this time period, Mr. Balfour agrees to pay £30 per month to Mrs. Balfour. But after a certain time, Mr. Balfour fails to perform his obligation or duty. Now after that, Mrs. Balfour filed a suit against court of law against Mr. Balfour. Now the court said that it is mere social or domestic agreement as it does not give rise to any legal obligations. So in order to form a contract, an agreement must give rise to enforceability by law. There must be legal relationships between the parties. Now, let us discuss essential elements of a valid contract. It makes more clear about enforceability by law. According to Section 10, an agreement to be enforceable must fulfill the essential elements of a valid contract. First essential comes offer and acceptance, which we already discussed, that is agreement. In this, one party offers and the other party gives us acceptance. So there must be offer and acceptance. Second, intention to create legal relationship, that is enforceability by law. An agreement must have legal relationships between them. Then it makes a contract. If it is a social or domestic agreement, then it does not give rise to contract. Third essential is that is lawful consideration. Consideration means something in return. Like in previous example where X offers to sell his car to Y for rupees 1 lakh and Y accepts the same. Now here X promised to sell his car for Y consideration to pay rupees 1 lakh. Similarly, Y's promise to pay rupees 1 lakh is for X consideration to sell his car to Y. Consideration may be in the form of money, services, or promises. It may be past, present, or future. Fourth essential is capacity of parties. The parties who are entering into a contract must have the capacity to enter into a contract. According to law, the persons who are competent to contract must be major, of sound mind, and not disqualified by any court of law. Fifth essential is free consent. The parties entering into a contract must agree upon the same thing in the same sense. Means their consents should be free and it should not be enforced by some other one. According to Section 14, consent is free when it is not caused by coercion, undue influence, fraud, misrepresentation, and mistake. Sixth essential is lawful object. The object of the agreement must be lawful. Object becomes unlawful when it is forbidden by law, when it is of such a nature that it would defeat the provisions of any law. It is fraudulent. It involves an injury to a person or property of any other. The court regard it as immoral or against or opposed to public policy. Then seventh essential is certainty of meaning. Means wording of the agreement must be clear and not vague or confusing for the concerned parties. For example, A agrees to sell B 1,000 tons of oil. Now there was nothing in the agreement to show what kind of oil it was intended to sell. So here meaning is uncertain in the contract. So that is make a invalid contract. Then eighth essential is possibility of performance. There must be such an agreement which is feasible to operate and exercise. An agreement to do an impossible acts which cannot be performed by anyone, then that is not a valid contract. So performance of the contract must be possible to perform. If it is impossible to perform, then it is not a valid contract. Ninth essential is not declared to be void or illegal. The court declared certain agreements as void or illegal, such as agreements in restraint of trade, agreements in restraint of marriage, agreements in restraint of legal proceedings, all are void agreements. For example, A agrees to transfer the ownership of his flat to B if B does not marry throughout his life. Now the agreement is expressly declared void as it is in restraint of marriage. So any agreements which are in restraining marriage, trade, or legal proceedings, then that are said to be void agreements. These cannot be said to be valid contracts. Then 10th essential is legal formalities. An oral contracts can be said to be valid contracts, but there are certain conditions where writing registration is required while making the contracts. For example, in case of sale, mortgage, lease, and gift of immovable property, negotiable instruments, there is a condition of registration, writing, etc. So, if certain legal formalities are required to be fulfilled, then that must be fulfilled. If that is missing, then again it is said to be invalid contracts. So, a valid contract is one which fulfill all these 10 essentials elements of contract. If any one of it is missing, then that is said to be invalid contract.